close, I'd like to ask each of you to take a couple of minutes and give me what you think are the key takeaways attendees should leave this webinar with. Whoever would like to start, feel free.
I'll start. So as I said in my presentation, this won't be a surprise to anyone. I guess the takeaways I would suggest is, one, the question of whether the SEC could even seek disgorgement, which so many folks have just assumed is now on the table, and that's interesting in its own right. Number two, and I'll stop with two, is that in light of this decision, defendants are given a little more leverage and bargaining power vis-a-vis the SEC in SEC enforcement actions.
Yeah, so I'll offer a few closing comments too. I mean, I agree with all of Ron's points. I think, again, just to echo comments I made earlier, the SEC is going to be, I think, a little more careful in the kinds of enforcement actions and the remedies that it seeks, and they are going to have tougher choices to make. And also, another point is that that's going to affect, this case is also going to affect what other agencies decide to do. And finally, I guess that we'll see whether the SEC really does indeed decide to push back on this case, as we've talked a little bit about, whether they decide to try to preserve these remedies as much as possible by carving them out a little more narrowly from what the Kokesh decision seemed to take away. So those are my takeaways.
May I amend my takeaway? In light to what Paul just said, which is I agree with completely. I mentioned this very briefly in my presentation, but we're just assuming that disgorgement might go away. There is the possibility that the SEC can go to Congress, right, and get explicit statutory authorization for that. It's a remote possibility the way the winds are blowing, but that's a possibility too.
Absolutely. Yep.
Yeah, this is Arthur. I agree with that, and I also think, given the Kokesh decision, and given the sort of regulatory and political winds, which are sort of going in the same direction, the SEC would only be able to get authorization for a very narrowly defined remedy of disgorgement that sort of dealt with all the issues that the court had raised. So in terms of other takeaways, in addition to that one, I would say what I mentioned earlier, the notion that statute of limitations in general, including in criminal cases and including in private civil litigation, have a real important function. And I think Kokesh can be cited essentially by defense counsel in a variety of areas. Some of the policy language sort of could give a boost to some more technical legal arguments about statute of limitations in these other cases, even if they have nothing to do with the SEC enforcement context. And then I guess another takeaway, which sort of we've all been discussing for the last 10-15 minutes, is sort of what's the future hold for other remedies, either a newly narrowed or reconstituted disgorgement remedy that's made to be purely remedial or purely compensatory, and what's in the future for injunctions. And I think those are both open questions, but I'm very confident that both the decision and the reasoning and some of the language in Kokesh will be part of the litigations on all those issues.